Hi, I'm Mike Delsignore, and I want to answer a common question people ask me all the time. Is domestic assault and battery a felony or a misdemeanor? And the answer, it depends on how it's charged. So it can be a felony and it can be a misdemeanor. A little bit about me. I handle domestic assault and battery cases and criminal cases all over Massachusetts. This is what we do. We help people who are in difficult situations, who find themselves facing criminal charges, and we help them get their lives back together. And one of the things that I like to do is make sure people understand the law and the court process. So this isn't an easy process. I can't make it what it isn't. You're charged with a crime. There's some difficulty in it, but I can make it a little more manageable. I can ease some anxiety. A lot of people have anxiety about things that they shouldn't have just through lack of understanding. So domestic assault and battery is normally a misdemeanor. A typical domestic assault and battery would be a misdemeanor offense. And the reason it's a misdemeanor is because the maximum penalty you could receive is a house of correction sentence, and that can't exceed 2.5 years. When an assault and battery is a felony is when it's assault and battery with a dangerous weapon, strangulation. Those crimes carry the potential of a state prison sentence. So if you have your complaint in front of you, you'll see the penalty phase will say house of correction 2.5 years, or state prison time up to 10 years. So the case, typically you're not going to get state prison time even on a domestic that's a felony, but it's still a felony offense. In other words, the only way you could get state prison time is the case would have to be indicted, removed from district court, and taken to superior court. For people with no record, that typically doesn't happen. There's not a lot of, most domestic assault and batteries, strangulation, assault and battery with dangerous weapon, most of those charges are heard in the district court. But nevertheless, if you're found guilty, it's still a felony conviction. So strangulation, assault and battery on a child, assault and battery on a pregnant woman, those are all the types of crimes that are felony offenses. So when you're convicted of a felony offense, you would have to take a DNA test as one of the consequences. Generally, you would get a supervised probation and other more rigorous conditions of probation, and certainly jail time is a potential. So in any domestic assault and battery in district court, you could receive a maximum sentence of 2.5 years in the house of correction. So regardless of whether you're charged with a felony domestic or misdemeanor domestic assault and battery, keep in mind that these are charges that are taken very seriously by prosecutors. Often people think, well, because the victim's not on board, the case will be quickly disposed of. Not the case. In almost all of these cases, the victim doesn't want to go forward with the case. Prosecutors still prosecute these cases because they know domestic assault and batteries happen, and they're concerned that it's going to continue to happen if they dismiss the case. So they make the cases take as long as possible. They do everything they can so that if the case is dismissed, it's not their fault. And they're backed into a corner sometimes. If the victim doesn't want to testify, they'll fight to have the case proven nonetheless. And here's how they do it. They'll try to find a 911 call. They'll try to go on any statements you made or 3 independent witnesses. Absent any of those avenues, they probably can't prosecute the case. But many domestic assault and battery cases involve 911 calls. So when your girlfriend, your spouse, who's ever claimed to be the victim, called 911 and they said, so-and-so hit me, he struck me, he's drunk, he's out of control, he's throwing things all over the house. Those types of statements that we hear all the time on 911 calls can come into evidence. Now, if they come into evidence like this, they're an exception to the hearsay rule. That the law is that those statements aren't accusing you of a crime. They're made to get help. And I don't agree with the reasoning, but that's how the judges will justify those statements coming in. Certainly sounds results-oriented. Certainly sounds like they're depriving someone of their right of confrontation just because the court and the public thinks this incident happened. But that's the law right now that we have to deal with. But there are ways to get it excluded. The right of confrontation is very important and a fundamental right, but it depends on whether the statement is testimonial versus non-testimonial. If the court says the statement is testimonial, then it doesn't come into evidence because they're saying that statement is the equivalent of in-court testimony. If they're saying it's non-testimonial, then it can come in because they're saying, well, that statement wasn't made with the primary purpose of accusing somebody of a crime. So the way this distinction happened is, it happened in a case, Crawford versus Washington. The U.S. Supreme Court created this testimonial, non-testimonial distinction. In 2006, the U.S. Supreme Court had another case, Davis versus Washington, where they came up with this idea of a statement can come into evidence if it's made to get help, to get assistance. And that was expanded in other cases by the U.S. Supreme Court. Now, Massachusetts Supreme Court has essentially followed the rationale of the U.S. Supreme Court. So it's going to depend on when the call is made. Are you still in the house? Is the argument still going on? Can you hear the argument in the background? Is the person calm? How long after the alleged argument is the 911 call? So when you take all these things into account, that's when you would make a legal argument about whether the statement comes in evidence. And there's cases all over Massachusetts and all of the United States where we would argue your case fits in the inadmissible category. The government will take other cases to try to persuade the judge that it should be admitted. But if you have questions about a domestic assault and battery, whether felony, misdemeanor, feel free to contact me. I'll help you through the process. We'll find out, one, can the case be proven without the victim's testimony? Is the victim on board? That's a completely different case. It's sort of the minority of cases, but if this person wants to come in and testify, then certainly we'll have to confront that person, find out their bias, their motive, why are they making this up to defend you. But in the majority of cases, the government's looking for other evidence, and we'll have to attack that evidence or see if that's in fact available. So whether felony or misdemeanor, the issues are the same. The stakes are high no matter what. You're looking at, if you plead to a misdemeanor or felony, generally looking at doing the batterers program in a probationary period. So contact me anytime, 781-686-5924. It's my cell. Call, text, Mike Delsignore. I'm here to help you. It's my passion to help people charged with criminal offenses get their life back together.